In the year 2000, Awqaf South Africa was pioneered as an institute of Waqf and the empowerment of communities. South Africa faces a diverse set of challenges with a high unemployment rate and a stark divide between rich and poor, where electricity, hospital care and water shortages plague communities and where lack of education hinders progress. Awqaf South Africa is a catalyst for change. As a charitable endowment receiving organization, Awqaf invests endowment funds wisely and ensures that only the income generated from investments is used to fund a variety of community development projects. We are excelling in all that we do with the highest standards of ethics, integrity, and sincerity of purpose. From masjid development, imam empowerment to sports development, orphan support, food security, and surgery support, Awqaf South Africa is paving the way by investing in the future of communities and uplifting generations to come. Awqaf South Africa, creating a legacy of hope.
يا حبيب الله يا رسول الله 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 هذا الرسول إذا يبسم ترى الأرض نورا فلا.
Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to this probably the third or fourth episode of the Waqf, the World's Week that we normally have on an annual basis. We started off in 2018 with a number of Sharia estate planning seminars, which were very well attended in Cape Town, Johannesburg, and Durban, and we're continuing creating consciousness about Islamic wills and Sharia estate planning. So with this, I'd like to just greet you all. Assalamu alaikum, and praise be to Allah subhanahu wa ta'ala for guiding us to this. Never would we have found guidance had it not been for the guidance of Allah. And welcome to all our participants that are logged into our YouTube and Facebook channels and platforms. And those of you that are not only in South Africa, but also abroad, a very warm welcome to you. The Sharia Estate Planning and World's Week webinar is quite an important event on our calendar, as we know that more than 80% of South Africans actually die without a will. And so this really becomes an important aspect of our lives. And hopefully we will get, our panelists to discuss more about it. We know that there are many family disputes. Families actually break down. Relationships are severed, and there's always issues around who gets what, and sometimes inheritances get usurped. So tonight we have an esteemed group of panelists in the name of Mufti Shafique Jakhura, who is a Sharia expert and who's a Sharia jurist at the Darul Ihsan Institute in Durban. We welcome Mufti Shafique Jakhura. And then we also have Sister Refqah, who is also an attorney, and she is involved with estates and wills at her firm of lawyers. And then we have Sister Yasmeen Suliman, who is also a tax expert at Bowmans. So alhamdulillah, I think we do have a good panel of speakers, and we hope that we will gain some insights from all of them. So our program for this evening will be that each of the speakers will be given a 10-minute slot where they would discuss the initial overview of, for example, the particular aspect that they're dealing with. Then we will go into further discussions. So we'll leave about an hour for questions and answers, and the first 30 minutes will be basically for their inputs and discussions. So with that, I'd like to firstly introduce Mufti Shafique Jakhura, who will be talking about the Sharia aspects of Islamic worlds, and perhaps he can even tell us a little bit about the importance of the Sharia worlds. So with that, Mufti Shafique, the floor is yours.
بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على أشرف المرسلين سيدنا محمد وعلى آله وأصحابه أجمعين أما بعد فقد قال الله تبارك وتعالى يوصيكم الله في أولادكم للذكر مثل حظ الأنثيين إلى آخر هذه الآيتين أو الآيات وقال رسول الله صلى الله عليه وسلم علموا الفرائض صدق الله العظيم وصدق رسوله النبي الكريم ونحن على ذلك لمن الشاهدين والشاكرين والحمد لله رب العالمين. At the outset, I would like to warmly welcome all of the participants to today's very important and very, very significant discussion that we are having. And I also want to take the opportunity to thank and commend Awqaf SA and Uncle Zeinoul and his team for having this particular program, which is one which has a lot of importance. I don't have much time to discuss, and it is hardly possible for us to even begin scratching the surface of aspects with regards to inheritance, with regards to winding up of estates. Suffice it to say that in this limited time available, we will only be able to create some sort of awareness around this particular topic. As a starter, perhaps, it is important for us to understand that everything that we have in this world, Allah subhanahu wa ta'ala has granted us some sort of ownership. So the Islamic economy realizes and recognizes that people can own things. We are not like the socialist economy in which everything is owned by the state. It's not like a planned economy or a government-based economy. We are entitled to private ownership, and the Islamic economy and Islam in general and its teachings does recognize that we are able to own things. There is one verse of the Holy Quran which we recite every morning in Surah Yasin, أَوَلَمْ يَرَوْا أَنَّا خَلَقْنَا لَهُم مِّمَّا عَمِلَتْ أَيْدِينَا أَنْعَامًا فَهُمْ لَهَا مَالِكُونَ. Do they not see that we have created for them cattle with our hands, فَهُمْ لَهَا مَالِكُونَ, but they are the owners of it. So Allah subhanahu wa ta'ala, if we ponder and reflect over this verse, it conveys to us a message that Allah subhanahu wa ta'ala is the creator. He creates and then he hands over and he gives. And therefore, it is Allah subhanahu wa ta'ala who actually has the ultimate say in matters. And when it comes to the Islamic law of succession, the same applies. We do not have the volition, the capacity, the ability, and we do not have the right to do with wealth that we leave behind as we will and how we will. We just do not have that particular right. Allah subhanahu wa ta'ala has stipulated who our Shariah heirs, our Islamic heirs are going to be. And not only has he stipulated who our heirs are, he has also stipulated in a great amount of detail how much each of them are going to be inheriting. And it is one of those aspects of Islamic law and Islamic jurisprudence in which there are not many differences of opinion, purely because Allah subhanahu wa ta'ala has articulated this in so much of detail in the Holy Quran in terms of who one's Shari heirs are, and who is going to inherit how much. And therefore, uh, it is extremely important for us to uphold the guidelines and the teachings of Allah subhanahu wa ta'ala in that regard. And particularly when a person is staying and he is living, or she is living in a as a minority in a non-Muslim country, and there is a chance that if a person passes away without a will, and it is called in the legal terminology, it is called when a person passes away intestate. He passed away or she passed away without a will, then the country's law of succession goes in, and that is something that will be implemented, and that in many cases and many instances may result in a distribution of the estate that is not in conformity with the guidelines and the teachings of the Holy Quran and the Sunnah of Rasulullah sallallahu alaihi wasallam. And therefore it becomes all the more important for us in this particular instance to uh, to prepare an Islamic will. I don't have much time, but I just want to give the listeners some sort of guideline as to what happens when a person passes away. When a person passes away, then the first charge on his estate is burial and shrouding expenses, which we refer to in Arabic as kafan and dafan or tajheez. We say uh, burial and shrouding expenses. We don't even refer to it as funeral expenses, because the catering that happens at the funeral, any other expenses that take place, those are not to come out from the estate. Once a person passes away, his that money now, the bulk of it belongs to the uh, to people, creditors who a person may be owing money to, or his heirs, but he no longer has those rights in that wealth, except to the extent of his burial and shrouding expenses. Number two is the second charge on the estate is if the person has left payables, debts that he left in his lifetime, then those debts are going to be paid off, even if they consume the entire estate and nothing is left for the heirs. Those are going to be paid off. There is a slight difference of opinion amongst the jurists and in the different schools of Islamic jurisprudence with regards to religious liabilities or religious debts, where a person may have some fidya to pay or some kafara to pay, or some maybe in certain cases blood money to pay. In those particular cases and instances, uh, there are some schools of thought that say that the religious debts will be given preference to over the others. But I just want to, there's no time to go really into the details. I just want to highlight that difference of opinion that is there. Then the third charge on the estate essentially is, and this is where a person has a little bit of volition, a little bit of option. He can do with 1/3 of his estate after the discharging of burial and shrouding expenses, after the discharging of debts. With 1/3 of whatever is left over, he has the right to bequeath that to anyone who might not be an heir of his. Anyone who might not be an heir of his, he can bequeath that. So maybe he wants to bequeath it to his grandchildren who may not be inheriting, they may not be heirs automatically. But he wants to bequeath it to them, so he can do that from that amount of money. Maybe he wants to give some sadaqah jariyah, he wants to give some waqf for that matter, since it is Awqaf SA who is running with this particular program. This is an opportunity that from his 1/3 of his allowable bequest he can do towards waqf, which will be a sadaqah jariyah, a perpetual sort of continuous sort of reward for him, so that he can do with 1/3 of his estate. The balance of his estate, he has to write in his Islamic will that it should go to my Islamic heirs as determined at the time of my demise, in the proportion stipulated by the Islamic law of succession. That is all he says. We don't have to name our heirs, who our heirs are going to be, simply because we don't know who is going to predecease who. In Islam, there is a sequence for coming into the world. My great grandfather came first, then my grandfather, then my father, then I, then my child, my grandchild, my great grandchildren, inshallah, and so forth. So there's a sequence for coming, but there's no sequence for leaving. And therefore, it's impossible for a person to determine who his heirs are going to be in his lifetime. And therefore, the Islamic will would merely say that the balance or the residue of my estate is to devolve upon my Islamic heirs as determined at the time of my death in the proportion stipulated by the Islamic law of succession. I think I have about 2 minutes left for my slot. I want to touch upon another very important aspect of ours, and that is many a times we are looking to sort of safeguard certain individuals from amongst our heirs and give them more sort of financial stability. And there is no harm in this so long as it is done in the correct manner, using the correct the correct procedures and the correct ideas. So a person may want to gift someone in his lifetime or in her lifetime. He might want to give them something a little bit extra to give them financial security. So whatever we do, it's fine. You are allowed to do those things in your lifetime, but we should never be gifting or sort of moving around assets with the intention of depriving an heir. That becomes problematic. We don't do things to deprive someone else. We might do it so that they can get a higher level of financial security because they require that, their circumstances are like that, and the Sharia recognizes those sort of things. There are things like gifting in one's lifetime, increasing the mahar of one's wife, and that might come as a surprise, but it is possible to post your nikah, after your nikah, to actually agree to increase the mahar of one's wife. وَلَا جُنَاحَ عَلَيْكُمْ فِيمَا تَرَاضَيْتُمْ بِهِ مِنْ بَعْدِ الْفَرِيضَةِ. So, and when you increase the mahar of your wife, that becomes a debt on the estate before the distribution of the estate. So this is one way that could be explored in certain situations. There could be other ways and means, but I often say to people, and I'll just terminate on that, and that is that if you're looking for the financial stability and the financial well-being of your spouse, of your wife, after she has passed away, the most important thing is to give your children a proper Islamic upbringing and to pass on to them true and proper Islamic values. Because if you do that, they will look after their mother. And if you don't do that, then it's very likely that you might leave for them, but they won't be looking after their mother. So this is also a very important aspect. I'm going to stop there because I don't want to overstay my welcome. But Jazakallah once again for the opportunity, and I hope inshallah that this is something of benefit, and inshallah at the time of the Q&A, if there are any questions, we would try and take some of those. Jazakumullah.
Okay, Jazakallah, Mufti Saab. I think really you've covered some of the major points regarding Islamic wills, and I'm sure that there are several questions, particularly those that you've mentioned towards the end as well, about gifting and so forth, that already people have started asking around those questions. Okay, so Jazakallah for that, Mufti Saab. Our next speaker, our next panelist is Sister Refqah, and she will be talking about the legal aspects of wills generally, and may also include some of the aspects relevant to Islamic wills as well. Jazakallah. Refqah, Ho-Yee, you have the floor.
Shukran, Uncle Zeinoul. Assalamu alaikum, everybody. It's so lovely spending the evening with you. I always take advantage of any opportunity to share as much as we can with those of us who are on the ground dealing with estates and wills, trusts and curatorships all the time. I head STBB Attorneys National Department of Wills, Trusts, Estates and Curatorships, and also then deal with the properties that are in an estate, and we transfer those to heirs or when those get sold. And so I wanted to, in a very short space of time before we head into Yasmeen's chat and then the Q&A, I wanted to touch on some of the practical aspects that we face every day in dealing with estate administration and also with estate planning. Because as Mufti said, we're fortunate in that the Sharia provides us with such a clear understanding of who inherits what, and so on. But unfortunately, we're also in a non-Muslim country. So we have to find that balance all the time in dealing with the fact that when we pass away, and as property owners, and some of us who are maybe married in terms of South African law as well as by nikah, you've got to find that balance between what that means falling under the South African legal system, and then of course the fact that we have our very specific rules and direction, alhamdulillah, in terms of Sharia. So no two estates are alike, and that's the first thing I want to tell you. So when someone says, oh well, this is what we did with my cousin's will, and this is what you did with your sister's, your marriage is so different to the next person, your family dynamic, the makeup of who your Islamic heirs are, and maybe also you could have gotten married in community of property, so that comes with an added bit of spice to the estate administration, because now we need to take into account that you can only attend to leaving half of the estate in your will and your estate, because the other half is automatically co-owned by your spouse. But we'll get into all of that in the Q&A. I live and practice in Cape Town, and so I deal mainly with the master's office in Cape Town, but as it's a national department, we do engage with the master's offices all over the country. But what's happening specifically in Cape Town, and also a bit in Joburg, but less so, I understand from my Durban and Pietermaritzburg colleagues, is that the master's offices in the country are moving towards an online reporting system. And that has an impact on who gets to administer the estate, because quite a few lay people feel that, okay, I can administer a simple estate, I'm nominated to administer my sister's estate, so I could certainly carry on and administer an estate when my brother passes away and I'm nominated. The difficulty that comes in now with online reporting is that the master's offices are less and less inclined to accept a physical reporting of an estate, someone coming into their offices personally. So bear that in mind, and especially if you're in Cape Town, the master's offices are insisting on online reporting. It's not to say a layperson can't act as executor, but you would then need to register online, upload everything online to the master's portal, and within a month to 2, sometimes 3, depending on their backlogs, they then issue an estate number based for that estate via email, and then you submit a cover letter to the master in person, enclosing original documents. And the original document that you must lodge with the master would be the original will. Irrespective of what that will says, it's Sharia compliant, not Sharia compliant, the original will still has to be lodged in person. And of course, with our Sharia compliant estates to be administered, the certificate of Islamic distribution issued by whichever Islamic body, the original certificate has to be lodged as well. So you will lodge all of that online and upload it, but the originals must be submitted. So, speak to your attorney, speak to me. We can certainly help you with that process. But just bear in mind that that's a consideration when you are thinking of taking up an appointment as an executor and when you're selecting who to nominate. And also SARS is another big government department that we spend a lot of time engaging with. And so the executor will have to have access to e-filing, or if the executor is outsourcing that to an accountant, then of course the accountant, I'm assuming, would have e-filing access. And the executor, interestingly enough, also has to have his or her tax affairs in place, because I act as executrix on thousands of estates, and the master certainly does keep an eye on my affairs as well. We'll chat about things practically as we go along. There's so many different schools of thought of what you can do and what you can't do in terms of Sharia. For me personally, I always go back to what is the purpose behind it. And, you know, the Sharia is all about fairness and justice and equity. And, and certainly I try to have those kind of estate planning consultations, and I like opportunities like this where we can chat about some of the more complicated estates. And so it's all around making sure that at the end of the day you are going to end up with your inheritance to your Islamic heirs, also knowing and understanding what the wasiyat is and who you can perhaps how you can use that wasiyat to benefit any members of your family or anyone that you're supporting who's not an Islamic heir. You can certainly use that 1/3 of your wasiyat to leave something to someone. We'll also chat about what you can do while you're alive. As Mufti said, there are things that you certainly can do and gift and donate and sell. And let's chat about that as well. But there are very specific processes. There are numerous government departments involved. And I think it's very important that whoever you nominate to act as your executor, whoever you nominate as trustee for a testamentary trust for your minor heirs, all of those considerations need to be taken into account as to whether that person can actually and wants to engage with all of those government departments. And the last thing I want to really just touch on very quickly is it's so important. People think about their Islamic heirs, who those people are. They think about the shares. They make sure that they have an executor nominated, that they have guardians for minor children, that they have trustees nominated for testamentary trusts that are created in the will. They think about all sorts of things, which is fantastic. I love those kind of clients. But often people overlook money, and that is having sufficient cash in your estate when you pass away to cover your expenses, cover your estate administration costs. It's lovely to be able to leave a property to heirs, but have you left sufficient cash to the estate so that the estate can actually transfer that property? Have you sorted out your taxes? I mean, none of your debts die with you. They're all still alive and kicking and come out of the closet. And so make sure that your taxes are in order. If you're self-employed, make sure that you've got the correct documentation for your shareholders agreements. You've still got a CC. Make sure that all of those things are in place. That you and your partners in your business understand what's going to happen should one of you pass away. Do you have sufficient cash assets to pay for your pre-death and your post-death taxes? And I find that that's the biggest obstacle in finalizing an estate is the lack of cash. And so the uncertainty that comes in around people not understanding what happens when someone passes away, not understanding what's going to happen in that balance between having a Sharia compliant will and then living in South Africa, and also that fear of the unknown adds to animosity, distrust, greed sometimes, and breakdown in family relations. So I'm glad that you're all online tonight so that we can help answer some of your questions, and whatever we don't get to, we'll certainly try to respond and answer the questions and get it back to all of you via Awqaf. Shukran.
Okay, Jazakallah, Sister Refqah. I think you've already highlighted so many pitfalls and so many issues that people need to be really wary about and really be conscious about in terms of what they should be. For example, you mentioned about the cash that people should have, and often people don't have the sufficient cash to actually do property transfers or even look after maintenance for at least a period of time until the estate is actually wound up. So I think you have raised a number of issues there, and hopefully we would actually be able to go through there. The issues about e-filing, the online requirements now that you've mentioned, I think will definitely create something new in terms of how estates are actually handled. Okay, so let's get on to our next speaker, who is Yasmeen Suliman. She's a chartered accountant, and she handles estates and literally looks at all the tax matters, at Bowmans, which is a very large legal entity, a legal firm based in Durban. So, welcome, Sister Yasmeen, and over to you.
Assalamualaikum. Thank you, everyone. Assalamualaikum. It's good to be here today. I just want to have to just make a short correction. Unfortunately, I'm not. I don't deal with estates on a day-to-day basis, but I do advise quite a few other practitioners who are dealing with estates themselves, and I help a lot of clients with their estate planning. As far as the active, winding up of his estates and so on, you guys probably better placed to give you more practical guidance. But I certainly want to highlight a few, tax issues that I've seen come up, when we consult with clients. What are the hot topics? So there's a few things. I've only got 10 minutes. I want to highlight a few important things for you to be aware of. The first is that you cease to be a taxpayer on your date of death, and a new taxpayer is formed, which is in the form of your deceased estate. So when you die, your death is reported to SARS, and effectively what would happen is that for that last period, from the 1st of March of that tax year up to your date of death, there is a tax return that's required for part of the year. And then following that, the estate then submits as a separate taxpayer with a separate tax number, a tax return up to the time the actual estate is wound up and all the assets are then distributed to the beneficiaries of your estate. Now, what is very important to know, and it comes as a big shock to a lot of taxpayers, is that when a person passes away, there's actually two sets of tax implications. The first is capital gains tax. So if you have quite a few assets that would be subject to capital gains tax, and the typical assets we talk of are things like property, shares in businesses. If you own any sort of precious metals, for example, Krugerrands, those sort of assets, those are all subject to capital gains tax at the time you pass away. And in addition to that, there could be estate duty as well. Often, a lot of taxpayers tell me, look, this is a double tax. It's been brought up with Treasury previously. They don't see it as a double tax because they say the capital gains tax is just to tax the appreciation in the value of your assets up to the time you pass away. And the estate duty is actually then a wealth tax that taxes you on the value of the asset itself. So they see it as two distinct things. But it becomes an unpleasant surprise to a lot of taxpayers to realize that actually on the day of death, there's two implications. Now, how it's dealt with practically is that in your final tax return, for that a part of the year that you're still alive, in that tax return, the capital gains tax on death is reported. Now, it's not all your assets, as I said, that would be subject to capital gains tax, and the normal exemptions do apply. So, the exemption for primary residence does apply. If you have a lot of loan accounts, if you have cash, those are typically not subject to capital gains tax. They really would be those assets that appreciate in value. It would be shares, unit trusts, it would be property, and as I said, like precious metals and so on. Then moving on to estate duty. Now, the estate duty, it depends on the level of assets you've got. So there's a sizable sort of exemption that applies, and there's various other exemptions that could come into play. The first one, the most common one, is anything that you leave to your spouse. And as long as your spouse is a South African resident, then an exemption, a spousal exemption that applies. So anything that you leave to your spouse will not be subject to capital gains tax or estate duty at the time you die. And it will only be at the time when your spouse dies, and if that asset is still available in their estate, that those tax implications will come to bear. Now, if you've got a Shariah will, obviously the amount that can be bequeathed to your spouse is limited in terms of Shariah. So you can't say, I'm going to bequeath 100% of my estate. I do see wills like that, where from a tax planning point of view, the taxpayer has decided I'm going to leave everything to my spouse because we're not going to trigger tax immediately. But you may be precluded from a Sharia perspective from doing that. So it's something to just bear in mind. So that's the one exemption. The other exemption is called the abatement. And essentially, that is the first 3.5 million rands of your estate, after taking into account the spousal exemption or any other exemption that may be applied. The first 3.5 million is not subject to estate duty. Now, if you've got very few assets, maybe just your primary residence and some pension funds and so on, chances are that 3.5 million will be sufficient. The 3.5 million is portable. So if the whole thing is not used, at the time you pass away, it can be sort of transported to your spouse. So between the two of you, you've got a 7 million rand abatement. As I said, though, your ability to use that could be limited by the fact that in terms of a Sharia world, there's only so much you can leave to your spouse. So something to just bear in mind. What the other types of exemptions or items that don't give rise to estate duty, which you could think of utilizing, would be like bequests to like a public benefit organization. So from your 1/3 of your estate as discretionary, if you want to benefit, create, a lasting legacy, and you want to leave some monies to for charitable purposes, if you bequeath that to a public benefit organization, that those assets do not give rise to any capital gains tax. So if it's an asset that you're transferring, that would be subject to estate duty, capital gains tax, or estate duty at the time you die. So if you, for example, decide you want to leave a property as part of your 1/3 as a Waqf, for example, to a public benefit organization, for example, to build a madrasa or have an orphanage or something like that, then you could do that, and that would avoid the estate duty and the capital gains tax on that particular asset. Right? Obviously, your ability to do that will be limited depending on the value of your estate. Now, the other item, the other issue that Refqah mentioned earlier on, which is very important, is liquidity in the estate. Having sufficient cash in your estate in order to make good on any liabilities, including tax liabilities. Now, what I've seen very frequently, and I think there is some debate amongst the Sharia scholars as to whether it's permissible or not permissible. And I think it's one of the questions later on about insurance policies, whether life insurance cover is permissible. I'm not going to give you an opinion on whether it's permissible or not, but the bottom line is, if you do have life cover, just to be aware that while there's no capital gains tax on life cover, it does the proceeds of the life cover, if your life is the one covered, unfortunately it does fall into your estate for estate duty purposes. So to the extent it exceeds it's not left to your spouse, and it exceeds the abatement, it actually, you have to factor in that there's estate duty that could arise on the life insurance proceeds itself. Right? So for example, if you've taken out life cover of say 10 million rand, and it's all going to, that part of it's going to your spouse, but the rest of it's going to your heirs, or you're going to leave it to your estate, then the part that's not going to your spouse is going to be subject to estate duty. And at that level, we're talking about a minimum of 20% estate duty that's going to be payable on the life cover itself, before counting any of the other assets in your estate. Then the other important aspect is retirement funds. So many people have worked in their lifetimes, have accumulated retirement funds, whether it's a provident fund, pension fund, or retirement annuity fund. It does not form part of your estate for estate duty purposes, because it's subject to a separate tax. So the insurance company that is administering that policy would apply to SARS for the directive, and that directive will dictate what tax is deducted off that retirement fund. And then according to the beneficiaries you've nominated on your retirement fund, the distributions will happen. So those are, so generally speaking, pension funds, retirement funds are excluded from estate duty purposes, for estate duty purposes. The one thing to note, though, is that to the extent you've had excess excess contributions to pension funds, provident funds, or retirement annuity funds, for some reason those were in excess of the amounts that you could deduct for tax purposes, that amount does form part of your estate. It's a very strange thing, but it's because of some abusive tax schemes that were undertaken by many taxpayers over a period of time, So to the extent that you've got these non-deductible contributions that you've made to your retirement fund, unfortunately, that falls part of the estate and part of the value of the estate on which estate duty is calculated. Now, when clients come to see me, usually come to see me because they've got amassed an amount of wealth in their name, and they want to know, how do I protect it? How do I make sure from an estate planning point of view, I don't have a huge liability on there? And the problem is that once you've amassed a amount of wealth in your own name, there's very little we can do to actually reduce that unless you give away some of your assets. So if you give away some of your assets to your spouse or to a public benefit organization, you're going to trigger some tax, immediate tax issues. So, I've had clients come to me to say, well, they want to make provision for their spouses in their lifetime, and that's fine. You can donate to your spouse in your lifetime, and that won't have any donations tax implications. There may be some. I don't think there's there may be some transfer duty or securities transfer tax that may be applicable. But for something like cash that you want to donate to your spouse, you can do that without any immediate tax consequences because there's no donations tax on it. Right? The only thing is to be aware of is that any income generated from that donation may be still taxed in your hands. But some clients are happy to deal with that because as long as they know that that asset is actually sitting in the right place, it's where they want that asset to go. Where you have a donation to someone other than your spouse or public benefit organization, then unfortunately you may have a donations tax implication. And that often is a stumbling block. It's too expensive for taxpayers to fund. So, when it comes to gifting of assets in your lifetime, while, it really does clean up your estate, make sure that the assets go to where you want it to be, especially if the distribution is not going to be, strictly, if it was left in your estate, it wouldn't go according to the Sharia rules from an estate point of view. The problem is that there are some tax costs that you may have to take into account in order to distribute it. I think I'm probably over time, but the one last thing I want to mention is that we often see trusts being used as a means for estate planning. They're still a useful vehicle, not necessarily to reduce taxes, but more to peg values of estate, so you don't have a growing sort of estate that is be subject to more estate duty in future. It does come with its own pitfalls because trusts are quite heavily regulated at the moment and can be quite expensive from a tax point of view. But I think I've overstayed my welcome for now, and I'm going to leave it to Uncle Zeinoul to take us into the session.
Jazakallah, Sister Yasmeen. I think that really has been maybe overwhelming to a lot of people. I think tax issues are always very, very tricky. And I think, with very good professional advice that comes, that can be given to clients and to people, with smaller and bigger estates, I think it's absolutely vital that people have a good understanding of all the tax issues, estate duties. You mentioned the issues between estate duty and capital gains tax. I think that's also critical. The issues about gifting during your lifetime and the donations tax exemptions, interspousal donations that can be given during your lifetime, as well as in your will, where spousal donations are made, provided they, of course, within Sharia compliance as well. So I think that brings us to our next session, where we'd like to entertain a lot of the questions that have already been posed, and we'll go through some of those questions. And I'm going to start off with the very first one here, where somebody's asking about what happens about personal life policy insurance, and maybe from a Sharia perspective, what is the permissibility and the extent to which we can actually use the funds that actually come out from personal life policies.
Jazakumullah for that. A very important question. Uh, in terms of conventional life insurance, the short answer is that conventional life insurance is not permissible. If we have in South Africa any entity that is offering the alternative of conventional life insurance in the form of takaful or Islamic insurance, then that is something that could be availed of. And I believe that there are options available currently for South Africans. So that is something that we must be looking at, I believe. If someone does have a conventional life policy, first of all, now that the Islamic one is available, we should seek the Islamic ones. But where the conventional is available, then it can be used to the extent of paying estate duty taxes, and also one could recover any capital or premiums that were paid into that. The balance over and above that, as advised by many of the scholars, should actually be given away in charity, because it was not a compliant transaction, if you like.
From a text perspective, and Sister Yasmeen could elaborate further, from a text perspective, the proceeds from a life policy, and assuming that it is a Sharia compliant life policy, would that come into the estate, or is that paid directly to a beneficiary?
So on that, I mean, regardless of whether it's paid to the estate or directly to the beneficiary, as long as it's the deceased person that is the life assured, that is deemed property for the estate. There are some exemptions, very limited exemptions. In most cases, the life cover, regardless of whether it's paid directly to the beneficiary or into the estate itself, will form part of the deemed property of the estate and will have to be accounted for in the L&D account, in estate duty calculation.
Okay. Here's another interesting question, and I think this is something that quite a few people have actually raised, where a person has got daughters and they've got vulnerable people in the family, and they sort of concerned that when they pass on, who's going to be looking after them? Have they left sufficient funds for them to take care of themselves? So can you, for example, for the protection of those vulnerable people, it could be the person's wife, it could be their daughters that are not yet married, or they may be, divorced, or they may be widowed, or whatever. And is there some way, apart from the actual will, to actually secure them during their lifetime, and say once the testator passes on, is there some way of actually maintaining that kind of protection? I think Mufti,
Can I come in there? I
Yeah.
just want to say that, look, in Islam there is a hadith and a narration in which Rasulullah sallallahu alaihi wasallam has mentioned that أن تذر ورثتك أغنياء خير من أن تذرهم عالة يتكففون الناس, where Rasulullah sallallahu alaihi wasallam said that you leave your heirs in prosperity and wealthy is better for you than you leave them destitute, whereby they have to stretch their hands before people. So, the first answer to that is that a person must work hard in his lifetime to leave enough for his heirs, And then, secondly, if there are means and mechanisms in place whereby he can avail of an Islamic life insurance product, which in many countries, by the way, is available, and it is referred to as life takaful or family takaful. So this is something that a person could very well consider. Other than that, of course, leaving behind some sort of, I feel, you can have something as a waqf. So maybe it may not be enough to sort of, or it may not be appropriate for a person to leave everything into his estate. He might want to create a waqf, all right? And this is a family waqf where he himself and his wife and children and his progenies to come, they are the beneficiaries of that waqf. That is also something that is possible. So then he creates a waqf in his lifetime. He is a beneficiary in his lifetime. After he passes away, his children and progeny are beneficiaries, and it can go on and on in that particular manner without being subject to the laws of inheritance. Uh, and he also gets sadaqah jariyah for that, subject to the fact that if for whenever his progeny ceases to continue, then it goes to some sort of perpetual avenue that generally doesn't end, like the poor, like the needy, like the destitute, and so forth and so on. So that also might be a consideration and a way to look after these vulnerable people in the family.
Mufti, just related to this topic as well, the Hiba Umrah, where, for example, I think in certain instances there is a kind of leeway in which you can actually register a usufruct for a vulnerable person to ensure that they are also given certain rights even after you pass on. And when that person passes on, then it goes back into the estate. And can you elaborate on that?
So it is true that there is a concept that is recognized by certain schools of Islamic jurisprudence as the Umrah concept, not the Umrah that we go for to Makkah. Umrah means from the word Umar, which means lifelong. So a person gives over something as a lifelong usufruct, right? But because there is a difference of opinion amongst the scholars about it, and because of the fact that this particular concept also has the potential of depriving certain established heirs of what their rights would be. So, had it not been for this Umrah gift that was given, or usufruct that was given in the lifespan, in the lifetime of this person, there would have been heirs to those items, and it could be that those heirs, predecease the person to whom the Umrah was given, and in that case, they would not actually benefit from what they would have inherited. So, because of that, I am more inclined towards using the Umrah in very specific circumstances, after sort of understanding the situation, and then you could give a guideline with regards to that. But there are other means besides Umrah that could be used as well. In the case of spousal, looking after financial security for the spouse, I mentioned increasing of the mahar is something which is very, very effective. This family waqf, it's a legacy of the ummah actually. There was a Sahabi, if I'm not mistaken, by the name of Zubair ibn al-Awwam, right? And look at the elasticity, the dynamism that he created in the family waqf that he had, right? So he put in, he created a family waqf, and he said that my children will be the beneficiaries of this waqf, boys and girls equally, right? Then he said in there that girls will cease to be beneficiaries once they are married. So he put in that condition as well. And then he put in another condition to say that if the girls are divorced or they are widowed, then they will become beneficiaries again in this waqf. So look at the conditions that he put in there. There's so much of flexibility in this sort of concept that it is something that we must really explore, and it is something that can give us a lot of solutions to many of our issues.
Jazakallah.
Can I just add?
Yeah,
Sorry,
sure.
Uncle Zeinoul, just add one point there. I did observe a client of mine that implemented a waqf together with a discretionary trust. bit tricky to put it together, but did manage to do something like that.
And Yasmeen, did they include it in the terms of the trust? So the terms of the Waqf, is that just included in your inter vivos trust that you register and in your trust deed?
Yeah, so there were specific clauses that they put in that mentions that this is the whatever is endowed to this trust is
Okay.
Waqf.
Okay.
It was still in terms of the trustees having the discretion to make distributions, but when they did, it had to be done in a certain manner, in terms of
Okay.
percentages going to which level or which generation and things like that.
Okay.
Okay. No, I
But
think
from a practical point of view, though, I just saw, sorry, Uncle Zeinoul, one of the questions coming up on the screen is that how is that treated in terms of South African law? It's still a trust that gets registered at the master's office. It's just the terms that of the Waqf are implemented in your trust deed.
It's a recognized form or recognized vehicle that you can use.
Sure. Yes.
So just coming into the whole issue of creation of waqfs and creation of trusts, because many people are saying that they would like to again protect their heirs in a certain particular way, and Mufti Saab actually mentioned the issue about the waqf, which can be actually housed into a trust in terms of a legal entity, by which you can actually separate your assets and create this with the niyyah of a waqf. So I think that's also quite important, that when you're creating this trust, if you either you're creating it purely as a way of subverting your heirs, or you're doing some funny business, hopefully not. But if you're doing it with a correct niyyah, then using the trust as a vehicle would be, the ideal opportunity. Refqah, could you perhaps elaborate on that?
Thank you, Uncle Zeinoul. I'm so mindful of trusts because on the one hand, they are attracting a huge tax, but they are certainly helpful in many circumstances, and especially when you've got heirs that are mentally incapable of inheriting or taking care of their own inheritance and managing their own finances or managing their own assets. So imagine, in terms of your Sharia compliant estate or your will, you've got one heir who is maybe mentally incapacitated. You've got another son who is a drug addict. There are all sorts of scenarios where you might even have a spouse who has early onset dementia, and now you've left one property, for example, to a number of heirs, and 2 or 3 of those heirs happen to have some type of mental incapacity. And then it's quite helpful when in your will you're creating special trusts. So you're leaving the inheritance specifically in terms of their shares. Your wife's still getting her 1/8, your daughter's getting half as much as your sons, but one of your sons might be a drug addict. So that is Islamic inheritance is actually left to a vehicle called a special trust, which is mentioned specifically in your will, so that that person's inheritance is managed for the benefit of that heir, and also so as not to create all sorts of implications around co-ownership by people who can't actually manage their own affairs. So a trust is quite useful, and when you've got a special trust, there are, of course, tax allowances and benefits as well to having it. And so certainly, in terms of South African law, again, it's finding that balance. So when you pass away as a Muslim in South Africa and you leave minor heirs, in terms of South African law, you still need to have testamentary trust clauses in your will so that any heir under the age of 18 will still inherit their Islamic inheritance, but that's going to be managed on their behalf by trustees of a testamentary trust as per your will until they reach a majority. So it is quite handy to still use those tools, and it is very beneficial when it comes to mentally incapacitated heirs.
Okay, I thought I'll just refer that back to Mufti Shafique. in a case like that, with regard to mentally disabled or otherwise disabled, and the Sharia share that they will inherit will not actually look after them. So is there some way in which special care is taken to ensure that those type of vulnerable people, uh, there's some special care and special way in which they are kind of protected? Like Sister Refqah has mentioned, creating a special trust within the world. But from a Sharia perspective, how would you handle that?
So, from a Sharia perspective, any money that devolves upon them in terms of the Islamic law of succession, that would go into that particular trust. Even in their lifetime, they would never have control over that wealth because it would be their guardians or whoever is looking after them who would look after their needs through either their own wealth, or if they were responsible for looking after them, they would do that without giving them access to the wealth simply because they're not capable of looking after their wealth. So that is what would essentially happen. Again, I would like to reiterate, if it is going to be inadequate or insufficient for them to survive off a certain amount that one presumes they would be inheriting, then it is important to put things into place in one's lifetime to make sure that that happens. So, caregivers, a Waqf sort of institution, identifying an institution that's going to be looking after them, leaving a letter of wishes, to say that I would like my other children, they must make sure that they look after. Because these things, for whatever it's worth, it has an effect on those people who survive you, and more often than not, letters of wishes are something that a person and a surviving family member they want to implement that and help. So these sort of things, it's important to do whatever we can to sort of mitigate those eventualities.
Okay. Simple question here is about marriages in community of property. How is that kind of handled from a South African legal perspective, a Sharia perspective?
Hmm. So I'll just touch very quickly on marriages in community of property. Uh, just being married, so the Sharia doesn't recognize the proprietary regime of being married in community of property, that everything is owned 50-50 just by virtue of being married in community of property. That is not something that the Islamic law recognizes. Every party owns whatever he owned or she owned. So the husband owns her assets, the wife owns her husband owns his assets, the wife owns her assets and her earnings. And that is how the Islamic, unless of course they have put in a mechanism to ensure that they own certain assets together, but that would be a separate arrangement, like a co-ownership arrangement, that we're going to own these assets together, and this is how it's going to be. But just by virtue of being married in community of property, that proprietary regime is not recognized in terms of Islamic law.
And
Okay,
and
so
yeah, so then you have to find, you have to really have a detailed will. And so then it's so important when people come and consult with any of us around estate planning, and you're sitting across from a couple who's married by nikah, but they're also married in community of property, and first to explain to them what that means in terms of African law. And if they then understand, well, as Mufti just said, well, actually that should be my property, but just by default of being married in community of property, you're now owning it 50-50. You then have to make sure that your will speaks to all of that and makes allowance for remedying all of that, because you're in South Africa, and so the South African legal system will recognize that your will is only going to speak to half of the assets, half of the property, half of the joint estate. And so you'll have to have clauses in your will. So for example, your wills should sort of speak to each other. So your and your wife's will need to then explain that on my death we have agreed or have a joint will or whatever, that this is what's going to happen to that property. So you have to be on the same page. If you both agree, well, actually, on the death of, let's say the husband passes away first and it's a marriage in community of property and they've got a joint property that they want to have left in terms of Sharia, then what will happen practically is half of the property is dealt with in terms of the late husband's will, and the wife's half share then gets transferred to those Islamic heirs. But then bear in mind, as Yasmeen and I spoke about earlier, you're going to have cash, so to implement all of these things, because now you're saying the spouse that's alive has agreed that we're going to then transfer her half of the property in the shares as well. But that's a transfer during her lifetime, so it might be seen as a donation, if not a sale. So you'll have to have the transfer costs involved, there may be transfer duty, donations, tax. So when we sit down, each family is so different, and we look at it and we look at how do we bring effect to Sharia based on whatever's going on with that specific couple, their assets and so on, so that at the end of the day we do end up with the desired result of the Sharia compliant shares, whilst at the same time making sure that the people that are left behind, as Mufti says, are actually not left worse off and are actually looked after financially. So it's all doable. It's just about sitting down with people and explaining how it gets unpacked and what it's going to cost, and making sure that they've got that in the kitty so that we can implement all of it at the end of the day.
So actually,
Can I
just
just ask a question? Can I ask a question?
Okay, go ahead. Go ahead.
If a couple is married in community of property, could they agree between them that they jointly own all their assets? Could that agreement be Sharia compliant?
So there is a concept that is known as Shirkatul Mufawada in the Hanafi school, and the Hanafi school recognizes that. But it also recognizes, and that is where two partners get together to say that they own everything 50-50, right? But the minute one of them owns something slightly more than the other, for example, one person was gifted something in his individual capacity, there's a lot of documents that look. I have come across when reviewing documents, because people give it to us to review for Sharia compliance, and that look, this gift is going to be to that particular spouse, and it's not going to have anything to do with marriage in community of property and so forth. So in that instance, that shirkatul mufawada falls away.
But only for that asset.
It falls away altogether, and the scholars say that it converts to a shirkatul inan, to a normal partnership then, because in shirkatul mufawada every single thing that they owned was supposed to be 50-50, and here one person owns something that is outside of that. Look, you can technically agree to that. But it would mean that if at any point someone was gifted something more than the other, then they quickly try and agree that this here is also gifted 50-50. So it's an ongoing sort of thing. I'm not saying it can't be done, but maybe there's more research required on that particular aspect.
Okay.
Uncle Zain, if I could link to this, there's a question that's come up in the chat around, where you're trying to remedy things, you're trying to put the puzzle pieces into place so that at the end of the day you're left with, the desired result. And this question that's been raised has come up quite commonly in other questions as well, which is often I get asked, and we've seen it in the questions today, what happens when someone tries to be all clever or fit the puzzle pieces in while they're still alive, and you start gifting or donating or selling an asset or a property or a share in a property to a spouse or any other relative whilst you're still alive, but you don't actually transfer it out of your name. So by the time you pass away, you still own that asset, but it's donated or gifted during your lifetime. But at the time of you passing away, you still actually legally own it. Um, Unfortunately, in terms of, so the first thing is, if you enter into any contract, that's still valid and binding against your estate. So whatever you intended to do, if you pass away whilst you're busy with a sale or donation, that certainly still gets implemented. Or if you say, I'm doing this during my lifetime and X has got to be done when I pass away, that can be implemented. But just bear in mind, when you're busy with your estate planning and looking at what your assets are and your liabilities and your liquidity, your cash, just bear in mind that anything still registered in your name at the time that you pass away is regarded as an asset in your estate. And so in your liquidation and distribution account, it's still accounted for there. It's still regarded for estate duty purposes. The value of your estate increases by the value of that asset. And so your estate costs and all the fees related to that and transfer costs are still taken into account. So even though you enter into those clever and helpful agreements during your lifetime, if you don't transfer that property out of your name, I'm using a property as an example, if you don't transfer it out of your name while you're alive to that person that you're donating it to or selling it to, it's still part of your estate for estate costs and taxes.
Just on that point, for example, where a person has actually said, I am donating this property to my wife, and this is like during my lifetime.
Yeah.
So what you're saying is that at the time of my death, because the property is still registered in my name, it would be regarded as my asset and in my estate. But if I were to have a clause in my will to say that this particular asset was donated in terms of a donation deed or whatever to my wife during my lifetime, would that hold?
It's still got, yes, the contract still stands and holds. You still have to follow through with that deed of donation or agreement of sale or anything. But in terms of the tax implications and also the cost implications, if that property is worth 3 million rand, your estate is worth the 3 million rand by the time you pass away. So often people draft these clauses thinking that they're reducing the value of their estate and sorting out family issues whilst they're alive, and thinking that they're reducing the value of the estate so that you're going to be left with a small estate, but then you need to transfer that property out of your name whilst you're alive, and that's not always possible for some people based on costs or whatever circumstances. So just keep that in mind. If people get divorced and the divorce order says the property's got to be transferred to my husband, in terms of the divorce order, but it's still in my name by the time I pass away and I didn't get around to doing it or didn't have the costs, cash to do it, it's still calculated as part of an asset in your estate, even though it's in the distribution, it's going to show who it's supposed to go to. It still has cost implications. So just keep that in mind and bring that up when you speak to your attorney and accountant when you're busy with your estate planning and working out the costs of dying.
Uncle
Okay,
Zeinoul, I
Zeinoul.
see a very interesting question that has come up in the chat, and that is on whether gifting can be done verbally or must there be an agreement in terms of it. So I want to maybe use the opportunity to address that particular question, because it's quite important for us to understand. Many a times we undertake a gift and that's the intention, but we don't follow through with all the conditions of the gift, that leaves it incomplete. So a gift in terms of the Sharia, the Arabic text of the words of the Jurist is Al-hibatu yan'aqidu bil-ijabi wal-qubul. A gift is effected by the donor offering the gift, the donee accepting the gift, but that's not adequate and sufficient. It also requires وَيَتِمُّ بِالْقَبْضِ. It only is effected, it's only complete when the donee is given unfettered rights and possession over that particular gift. You know, many a times what happens, and we see this, is that there is offer and acceptance that's taken place, but donee isn't given possession over it. He or she can't do with it as they want to. It's still, for all intents and purposes, in the control of the donor. You know, in that case, the Sharia doesn't recognize that as a valid gift. And it's important for us to understand that with regards to the question about whether it can be done verbally or it should be written, of course, for purposes of estates, it's better that it's written. But it does take effect if it happens verbally, provided also that possession is granted. In such a case, it would be very useful to have witnesses there so that you don't have problems in terms of disputes going forward. And if it's in writing, then that's much better, really.
Okay, so here's a question in a similar vein. What's the easiest way to leave my house to my daughter? Because I don't have anyone else, I just have a daughter. What's the easiest way to leave my house to my daughter and still stay in the house until I die?
You know, in situations like this, I have been advising people. Look, it's not a general advice. Every situation would be different. But people who have no children, for example, or there's only one child that is there, I have actually been advising them to create a waqf and make themselves the beneficiaries of that waqf. And look, this is established from the hadith, right? There's a hadith. People ask, how can I make a waqf and I myself am a beneficiary of that waqf? Rasulullah sallallahu alaihi wasallam told, made an announcement once when he moved to Medina, and there was a shortage of sweet water in Medina. The water was brackish, and Rasulullah sallallahu alaihi wasallam was encouraging the Muslims to purchase the well of Ruma. You know, the famous well that Sayyidina Uthman radiallahu ta'ala anhu purchased. So he said, "May yashtari bi'r Ruma فَيَجْعَلُ دِلْوَهُ فِيهِ كَدِلَاءِ الْمُسْلِمِينَ." Who will purchase the well of Ruma and make his bucket in it like the bucket of the Muslims? In other words, just like how all of the other Muslims are going to benefit, he can also be a beneficiary of his very own waqf. You see? So this is an example where you can create a waqf, right? You yourself can be the beneficiary of the waqf and whoever else you stipulate. So in a situation like this, it might be very, very advisable for the sister in question to create a waqf for the purposes that she wants to achieve.
Okay, but now just coming in with the same sort of way in which we can dispose of an asset through a waqf, there are some tax implications to that. Because now we're creating, because it would have to be created in a trust, and the beneficiary of that trust will be my daughter. So now, because it's a daughter that's actually the beneficiary, if there's any income that's generated out of that will be taxable, or would there be the fact that the person is actually just has a usufruct or has a benefit out of the asset that was created out of this waqf, from a tax perspective, would there be some deemed income, or or like?
There is a couple of tax issues. I think the first tax issues that would arise would be around the transfer of the asset into the trust or the waqf in the first place. You know, and if it was a straightforward sale of an asset, then typically the trust, the waqf, assuming that it's in the form of a trust, the trust wouldn't have any existing assets to pay for that for that quantum property that you're transferring into that trust, right? So you'd create a loan account in favor of the individual that's transferring the asset. There's transfer duties that may be applicable. If you decide you're not going to transfer it as a loan, through a sale, you're going to donate the asset, there's donations tax as well as capital gains tax that you may have to think about. So, transferring the asset does come with its costs if you're transferring it directly into a trust. So that's the first part. There are instances where there's large amounts of assets, we are able to transfer assets into a trust structure without necessarily triggering the taxes, but then not into the trust itself, maybe into a company owned by the trust. But that's a bit complicated for a discussion here. So that's the first aspect. And the second aspect is the income coming out of that asset, right? So assuming it is an income generating asset, then the normal trust principles apply. If the income is retained in the trust, it's taxed at 45%, flat rate of 45%, which is quite expensive. And if it's distributed to the beneficiaries, then it's taxed at their marginal rates, assuming that obviously the beneficiaries are South African resident. So, there's a trust structure to run a Waqf, it could be quite useful, but I think there are some pitfalls in terms of, making sure that, the way you transfer the asset into the trust is done in a tax efficient manner. Sometimes unavoidable, you have to bite the bullet and pay the tax and get it done so that you can have certainty. But there are ongoing tax implications. There's also administration of the trust that you need to worry with going forward and things like that.
Okay.
So, Refqah, I don't know if you've got anything to add to that.
Yeah, I mean, I take both of your points. It is a very useful tool, but it's a very expensive tool. And if I look at that question of the mom saying she's just got the one daughter, we're just chatting generally because you don't know all the details of that family. I would want to know, why would she want to transfer it now? Is she just thinking, well, I'm going to leave it, transfer it to my daughter now, as opposed to, my daughter inheriting with any other heirs as well? So I suppose it's about understanding what the reason is behind that. If she's only got the daughter, and I'm not sure which other heirs are out there that she'd be a bit concerned about. And so if you've got any of those scenarios where you're just concerned, as we saw, lots of the questions are around daughters.
So Refqah, probably sorry to cut you off, but what it would mean is that in this particular scenario, her daughter would only inherit half of her estate.
Yes.
If she doesn't have anyone else, then the other half of her estate is probably going to go to her siblings.
Yes.
And maybe not to deprive her siblings, but maybe her daughter needs more than half, and that would be the motivation for her to consider this sort of thing.
Yeah, and I think the difficulty, Mufti, comes in where people, we can suggest all those wonderful avenues, a Waqf, registering trust, as Yasmeen says, just the cost implications are sometimes quite prohibitive for people. And so it's about, I think that's the biggest concern. It's you've got your heirs, and especially when you've got daughters and no sons, and now you've got your siblings who are going to inherit with your daughter. It's about understand the family dynamic, and the families to understand that my daughter needs taken care of, and she's only going to inherit half the house. And what are your brothers who maybe now going to inherit half of that property with your daughter? What are they going to do to assist to make sure that she's well taken care of? I think it's part of a bigger, family conversation. But I think the costs are largely prohibitive for many people. When I sit across from them and start unpacking, as Yasmeen says, all the cost implications and the taxes associated with creating that trust. But sometimes you just have to bite the bullet if you are by the means to create those structures.
I see there's a comment here which says that depending on the value, the woman could simply transfer the house into the daughter's name at an agreed upon value with the condition of life usufruct. And I just want to point out here, I mean, yes, you can transfer. Transfer comes with costs, and not only legal costs, but there could be transfer duty. And at what value? So when you transfer an agreed value, does that mean the daughter has to pay for it? So it doesn't have the means to pay for it, there would be a loan created that would actually fall into your estate for estate duty purposes, and I assume for Sharia purposes as well on your death. So, there you may want to consider, instead of just simply transferring at an agreed value, you may have to go to the extent of donating the asset to your daughter outright, which comes with the associated tax costs, which we've mentioned as well. So I don't think it's an easy or straightforward sort of solution, unfortunately, for this kind of thing.
And if I can just, sorry, Uncle Zainoul, I just want to say one quick thing about that question, following on to what Yasmeen said. When people say, you can just do this, or you can simply transfer, there's always a causa, there's a reason behind it. So when you're transferring, it's either based on sale or donation or divorce or inheritance. So you can't just transfer property into someone's name. There has to be an underlying cause and a reason behind it. So in this case, just based on your wording, it would be a donation, and that just means unpacked, donations, tax, and transfer duty, and. So you'd certainly have to speak to someone to see what the most cost-effective option is for you.
Yeah, look, I mean, the practical reality is that people are kind of reluctant to do these kind of transfers in their lifetimes because of the costs involved. So, for example, I know of a case where this person had two houses. He's only got one daughter, and what he felt was he wants to give one of the houses to the daughter, and the daughter's already practically living in that house, and he's got no further. In fact, she pays all the rates and taxes and all of that. So effectively, she is she is the de facto owner of the house without the actual transfer taking place. So he's been given kind of advice that, look, just leave it as is, and then through your will, you'll be able to then donate it to her as a totality. So in other words, it won't go through as a normal Sharia sort of distribution, because the distribution has effectively taken place. But then if we take it to in terms of actual words written, because it will now still fall within the father's estate, and then he would have to pay whatever estate duties, etc., on it, and then get it transferred. But the point is that the Sharia compliance has probably been compromised here.
Yeah.
And
The Sharia compliance could have been compromised, maybe in a situation like that, just to manage it, because it's also open to challenge, right? If it hasn't been transferred out of his name, heirs could challenge that decision in the absence of any documentation giving effect to that. So probably it would be advisable that if someone has done that in his lifetime, they've given over something, but they haven't effected the legal transfer, then it's probably an idea to create some sort of affidavit or document or counter deed to say that although this item is in my name, I have effectively given it over in my lifetime and it should not form part of my estate. Now, what the legal implications of that is going to be, I don't know. But for the heirs, it serves as some sort of guideline for them.
What I wanted to add to both what Mufti is saying now and to what you were saying a few minutes ago, Uncle Zeinoul, is that when I sit across from clients like that, you'll say, I'm concerned because, in terms of Sharia, my house is going to go to half to my daughter and of course half to my siblings, but I really want her to have the house. Like life insurance policies and, those type of avenues, if you can find, the ones that work for you Islamically and so on, they're quite handy, because I'll sit down then and say, okay, your property is worth, say, 2.5 million rand. That means we've got to find 2.5 million rand, to to pay your other heirs. And then sometimes those policies are quite handy, because if that person is by the means to then pay towards a life insurance policy, for example, or just sort of increase that the cash liquidity in that estate, or have some type of policy where you're going to have that value that your heir is still going to, it's just trying to work practically so that your daughter ends up with the property, your other Islamic heir, your brothers or whoever, ends up with that value, that same value that he's supposed to get, but in a different format. So people need to also think practically and think, okay, I don't want 5 people to inherit this house, or they don't get along, but there's nothing else that I've got. Sometimes those policies are quite useful, because you can then sort of equalize the values and the Islamic share values to say, okay, you know what, I can give you your inheritance, you're going to get in the form of cash, and someone can get the property. And so there are all sorts of things that we can hopefully try to do, because we don't live in that perfect world where people are going to all do the right thing and look after each other and so on. So sometimes you need to look at what assets do you have that could be redistributed properly amongst your heirs, so that they don't all end up co-owning a property, or that someone doesn't get put out of a property and the one that you want to actually live in that property ultimately. And
So
sometimes you have to sell something. I always try and avoid selling the property, but sometimes there's nothing that you can do, and there's so much fighting that the property's got to be sold. Hopefully mom's already passed away, and it's just your children fighting, and then you sell the property and they get their share, and no one was living in the property, hopefully. But it's not always the case.
Yeah.
Okay.
So that's one particular way of doing it. Another way, and I just want to share it because there's a lot of practical. It's very beneficial, perhaps. There was a person, a very senior alim of Durban, who sort of sold his property. He left a son and 2 daughters, and a spouse, a wife, when he passed away. And in his lifetime, he sold his property to his son at a market related value, right? And the father then passed away, and the son was still owing the money. So that helped, because now he was owing the money to the father's estate. The son got the property, and the daughters and the widow, they were able to share from the cash proceeds that the son would pay into the estate. So that's one way of doing it as well.
Yeah, very helpful.
Okay, let's get to this where, on the one hand, a person passes on, but doesn't have a will at all. Okay, and in another scenario, a person passes on, but has no heirs. So the intestate, what happens, and what are the practical ramifications of a person dying without a will? Well, let's look at that one first.
Okay. I'm going to quickly jump in just from a South African law point of view and what actually happens and the problems I find. So, number one, you want your estate to be to devolve and to be administered as quickly and as cost effectively as possible. And as soon as you pass away without a will in this country, just adds to the drama and the delays, because now you've passed away intestate. And one of the biggest problems we have with intestate succession in South Africa is there's an insurance policy called a bond of security. And a bond of security is normally excluded in a will. You would have seen the clause in the wills that say, my executor is exempt from furnishing security to the master. That's normally in most wills, or they should be. And that means that the appointed executor, a nominated and appointed executor, doesn't have to take out this insurance policy to sort of, it's based on the value of the estate. And interestingly, the estate pays the premium on that until the estate is administered, not the executor. But it's an insurance policy to guard against negligence and fraud on the part of the executor. When you take out a bond, when you die intestate, and if you've got an estate that's very quickly worth 250,000 Rand, because then that's an estate that's got to be administered in terms of the normal course of events in South Africa. when you die intestate, only a spouse or your child can be legally appointed as executor to be exempt from a bond of security. So you pass away, you no longer have a spouse, and you might not have a child. You might only have grandchildren, or you might have never had children. So if my sister passes away, she doesn't have children, and let's say, she's not even married, and then you're stuck because now that whoever administers that intestate estate has to take out a bond of security. So that's an unnecessary expense. And then also all the additional paperwork and getting someone appointed, and all the dramas at the moment with the master's office and online reporting. I definitely don't recommend it. And of course, we want to ensure that our estates devolve Islamically. And in terms of South African law, the default, of course, is South African law of succession. And so if you pass away intestate and you haven't left a will which says my estate is supposed to be divided Islamically, South African law of intestate succession, which is freedom of testation, and it's got a completely different set of who your heirs are, those in intestate heirs in terms of South African law now need to all agree to redistribute your estate in terms of Sharia. You'll need 100% agreement, not 90% or 99%, 100% agreement by all of your intestate heirs that you all agree that your estate will be divided in terms of Sharia. And that in itself seems so straightforward sometimes, but it's not in practical circumstances where people start getting all, suspicious and try to be all clever. And so it just adds to the drama. And so best, of course, is to have a will. I'm not sure if Mufti or Yasmeen want to say anything before we go on to the next point, which is interesting when you pass away without an heir in this country. Not sure if anyone wants to say anything, but if I can quickly say what happens when you actually pass away, in terms of African law.
So before you go
Carry
on there, if there's in that scenario where the person passes away without a valid will, now we have a problem from a Sharia perspective that how do we actually go about distributing? Now, Refqah has mentioned that they'll have to have a kind of redistribution agreement, and that is if 100% of the interstate heirs actually agree on that. In a Muslim country, it's kind of automatic that the will be, even if you die without a will, I suppose it's sort of taken for granted that there'll be Sharia distribution. But what happens in a South African scenario? Have you come across cases where people have passed on without a valid will, and now they're clamoring to get the Sharia compliance into place?
Yes, so you do come across that, and it becomes difficult, and therefore the emphasis on everyone to prepare an Islamic will. And it's really not difficult to do that. A lot of people believe that, you get emotional about it, that, look, if I start preparing a will, that means I'm going to die. These are things that come about, but it's not like that you will die at your appointed time. Some people feel that if they start dying, then they will start dying, uh, you know so but these are things that we must do. And let me tell you, with the standard wills that are available, from the Islamic organizations, from the Jamiats and the Darul Ihsans and so forth, it's actually a very, very easy thing to do. If you don't want to do, or you don't have the time to do a very complicated and detailed will just yet, right now, just get a standard will, have it signed and witnessed, and it'll take you less than 5 minutes to do that, and make sure that you have that first. So at least if you die, you don't, or not if you die, when you die, you're not going to uh, put your heirs through the troubles and the difficulties of a person passing interstate, because, as Sister Rifka mentioned, it's just an additional layer of difficulty and running around and all of that comes into place. And therefore our our legal system and the country at large has this Wills Week and Wills Month and all of that to actually encourage people to put these affairs in order, which is very important.
Okay, so Jazakallah for that. I think the important and the emphasis that you're making, Mufti Saab, is that we should have a will, even if it's just that document that is signed and properly signed, of course, and properly witnessed, so that at least you're not going to put your heirs into a very
So when we say
problematic situation.
like properly signed and properly witnessed, there's actually guidelines with regards to that, right? So a beneficiary to an estate can't be signing as a witness. So we need to be careful about who we get to sign as a witness. One of your heirs may not be the ideal person to be signing as a witness. So you must get outsiders or someone else to sign as a witness. Make sure that will is in a place and people know that that will is there. All of these things are very important aspects because there's no last phone call that you can make or SMS that you can send or WhatsApp that you can send to anyone once you're gone to tell them that's where I left the will. These and that's the life of a Muslim and a mu'min and a believer. We are looking forward to the akhirat. We are preparing for the akhirat, and that's the reality. And this is just if we have our wills prepared, it's actually a means of preparation for the hereafter. It keeps a person in check and reminded of his journey to the akhirat.
Just before we get on to that issue about dying without or without heirs, you just mentioned something about having our wills sort of, knowing where they are and all of that. Now, I know in some countries, like in New Zealand, uh, many times we're looking at preparing a will and it's put somewhere in a file somewhere, and our family doesn't even know where that will is. So when we pass on, everybody's running helter and skelter to look for this particular document. So what happens in New Zealand? They actually do an original will in triplicate. So one will is kept by the person, one will is kept by, for example, an executor, and the other will is kept by maybe a close family relative, a parent or somebody. So I don't know whether you've come across a situation in South Africa, because I think that in most cases, the people don't even know where the wills are kept. So have you come across a situation where people are, or this, where we've got like multiple copies of the same will kept by at least 3 copies kept by 3 reliable people?
Mm. So we have that at Darul Ihsan. Some people, it's not a service that we offer, but some people insist that they want to keep one copy of their will at Darul Ihsan. And it might be an idea for accountants, for lawyers, for administrators to be keeping copies of those wills. So very, very important, I think, because you can have your will prepared and ready, and if no one knows about it, then
It's
your
meaningless.
heirs can only be that dynamic after that.
Because like in some of the wills, people would also sort of have a clause to say, say something about their burial, and especially like we're getting a lot of let's say people coming into the fold of Islam, and their wills and they have family disputes about where they should be buried and all of that. So those particular wills will have specific clauses, and they have this actually. Again, I'm quoting the example in New Zealand, where they actually have to specify where they should be buried and how they should be buried under Islamic rites and so forth. So, especially for people that are coming into the fold of Islam, those are kind of important, clauses to actually insert in your will. Okay, so coming, yeah,
I
sorry.
agree, Uncle Zainal, I agree with what Mufti and what you've just said about the wills and making sure that people know that you have a will. And as Mufti says, when people start talking about wills, they start thinking of their mortality. It's not up to them, and so they it's taboo, and no one wants the family to know that I exist and I drafted the will. But it's so important. So at STBB, we keep the original wills in safekeeping, and then we give the client a copy. Um, and then we email the client, if the client's on email, and ask them to then introduce us to their family members or forward that email. Or I get their children's email addresses, and without disclosing the terms of the will, if they don't want me to, I'll just introduce myself so that everybody in the family knows that I exist. I'm sitting with your mum's original will. Should something happen to her, I always recommend that people leave a copy of the will with their family doctor, because as you said, that's probably the person that they're going to call when you pass away. And then, that person also has the will to know how you wanted to be buried, where you must be buried, all of those sort of things if your family doesn't know, and certainly people coming into Islam. So let your GP, maybe someone who is that close to you, who might be the person who's going to have to sign the death notice anyway, at least know what's supposed to happen to you. But yeah, just be practical and notify your family members that your accountant exists, that your attorney exists, and then they'll know where to find your will. Because what happens is, what happened last week, for example, is my team and I were administering an estate, and we're almost done with the estate, and no one knew there was a will. The family actually all signed the redistribution to say that they wanted everything to devolve Islamically. We got the MJC Islamic distribution certificate. We were almost done with the estate, and then someone whipped out a will. And so in terms of course, the Islamic heirs were the same, but the wasiyat was different because that person had dictated, which specific charities they wanted. So it got a little bit sticky. But anyway, the will was obviously found to be valid, and the master accepted it, and we had to, of course, implement the terms. So it was interesting.
Okay, so a person passes on without having any heirs from a South African perspective and from a Sharia perspective.
So in terms of South African law, the Master's Office will insist that you show that you've tried to find the heirs. And so you've got to show all the steps that you've taken, if you've advertised, if you've got affidavits from, neighbors, everybody in that person's life to confirm that you've actually not found anybody. So it's quite a process. And sometimes you do find someone, and it's nice to contact some long lost relative to say hello, you've actually inherited things. But interestingly, if you can't find an heir, people always say, oh, you forfeit everything to the state. It does actually go to the Guardians Fund at the Master's Office. And the Guardians Fund is a facility at the Master's Office where they hold someone's inheritance, for example, for minors, where you pass away and you haven't left a will, or you haven't left a testamentary trust in your will, and you've got minor heirs, then the inheritance is kept in safekeeping at the Guardians Fund. So it's similar process, but you have to go through quite a process to prove that you've tried to find heirs. But if you really can't find someone, it does devolve upon the state, which is interesting.
Mufti, from a Sharia
From an Islamic perspective, from an Islamic perspective, when a person passes away and there are no heirs, first of all, to determine once again that there are no heirs, the Islamic laws of succession, they go quite far. So in certain instances, there may be paternal uncles that could inherit, there may be nephews or cousins that could be inheriting, or very distant relatives also in some instances that could be inheriting. If perchance there is really, really no one, this is the last person in that family line, then of course in a Muslim country, whatever he left behind would go to the Baytul Mal or to the National Treasury, you know. And maybe in a non-Muslim country, if someone finds himself in that particular instant, then probably you would give it to a bona fide Muslim organization or charity, and that's where those funds and that estate should devolve upon them, so that at least it goes back into the community.
Yeah.
Okay.
And
Look,
Uncle Zainoul, that's why it is so important to have a will, especially if you are someone who doesn't have children and you haven't married and you are unmarried and getting on in your years. It's so important for all of us to have a will, but especially those people who don't have spouses and they don't have children. Just make sure that you do have a will, and even if it's just a very simple will. And you know I saw a comment on one of the previous questions that came in where someone said, why do I even need a will? I don't own much. But you own something. If you're in South Africa, you probably have a bank account. And let me tell you, trying to close a bank account on an interstate estate, it takes a very long time. And then you also just, there's costs involved in trying to get someone appointed on an interstate estate and maybe even bond of security just to close a bank account. And we haven't even gone into things like foreign bank accounts, but chat to your attorney or your accountant to get hold of us if you've got offshore things. I've got one where this client literally only had a bank account in South Africa and a bank account in the UK. And years ago, she did the 2-year stint where she, as a young person, she worked in London and she ended up having a bank account over there, and she's got like £5,000, which is a fortune in terms of rands, but it's costing £2,500 to close an account with £5,000 in. So just get your basic will at the very least signed and witnessed and kept in safekeeping by somebody.
Uncle
Okay.
Zainoul, they say in English, where there is a will, then there are heirs.
Oh,
Well, they are heirs.
so true. Okay. So, you mentioned something where somebody will have a bank account, and that may be the only possession that they have. And you find many families where they open up bank accounts for their children. And the moment they are 16, they should actually have a will, because I think that's the minimum age limit or minimum age where you are required, or you can actually have your where you should be able to have your own will. Is that correct?
Yes,
The,
and I agree with you. You should, because so many people put away money and you take advantage of tax-free savings accounts and all sorts of things, and before you know it, your children actually have a little bit of an estate.
yeah. Okay. So look, we are running out of time now, but let's just there's one question that's related to Waqf, and this person is asking how to make a Waqf on property shared with a sibling. So this person probably has a property, and they own the property on a 50-50 basis. So one of the siblings want to make her share a Waqf, whereas the other person is not making the Waqf. So,
Hmm.
in other words, it's a shared
Yeah,
Waqf.
yeah. So I'm not sure whether an undivided share could be regarded as a waqf. That's something that one would have to check. It's called al-hissatul musha'a in Arabic, an undivided share, where you own every part of that property 50-50, and one of the partners would like to make their share of that property waqf. I have really, it's not in my mind at the moment. It's something that would probably have to be checked. Uh, you could probably uh, give it over your share. You could give it over to a waqf, then it would be owned by a waqf, but it won't be waqf itself. That's something that is definitely possible. But actually making a share like that waqf, it's something, I must be honest, it's not in my mind, and it would be
Okay.
something quite interesting to check on.
It is interesting. And in terms of South African law, you can, co-ownership is possible where a trust, a registered trust in South Africa can own, half a property with me, for example, with a natural person. The banks don't obviously like to bond it, but certainly if you've purchased a property cash, we've got all sorts of scenarios where different co-owners, own with natural persons, with trusts, with companies. So the co-ownership is possible, but of course, from the Sharia point of view, we'll wait and hear from Mufti.
Yeah. Okay. So I think perhaps in conclusion, perhaps we should just look at what people should be careful about and how they should actually manage the will itself. For example, the advice from various tax planners and estate agents, I'm not estate agents, but estate planners, is that maintain a file. And in that file, various documents. And for example, in today's times, give your spouse your uh, your telephone or your cell phone passwords, or your computer passwords, or your bank passwords, because those are now, well, when you pass on, you're leaving a person without any knowledge about all these nitty-gritties. So can you just talk us quickly through those kind of issues of what are the important things that people should know, and documents that you should actually keep, so that everything is kept intact, whether it's
Sure.
water and light accounts, or assessment rates, or telephone accounts, or whatever, insurance policies,
So,
whatever.
So, Uncle Zainul, I'll jump in. There's a near document which I'll share with you so that you can share it with everybody. There are two documents, and through Awqaf you can share it with everybody. It's a nice checklist, and then there's also what we call a live file, so you can store all of that information. And so it's your basics. Number one, it's your FICA that you deal with all the time. So know where your original ID is, your marriage certificate. If you've got your marriage certificate in your old ID book, if you're an older client, then certainly make sure you haven't destroyed that that ID. If you are living outside South Africa but you have a South African ID, please make sure that you know where that South African ID is. That thing is gold. If you left South Africa as a small child and you don't have a South African ID but you have a birth certificate, I hope you know where that is. It's ridiculous how the master's office will not deal with your estate, will not let us deal with your estate if you were previously a South African resident, or if you were ever issued with a South African ID. Between SARS and the master's office, they'll certainly want a copy of that. And we have to go to Home Affairs, and you know how long that takes, like 6 to 9 months at least, to get a copy of your original birth certificate. Your marriage certificate, of course, if you were married in terms of South African law. The master's office is quite aware that our talaqs are not necessarily reflected in a piece of paper, so that's also has been okay. But if you've got any documentation about a fasakh or a talaq, then certainly keep that. If you have come into Islam and you've changed your name, very, very important. When you changed your name and you took on maybe, a Muslim name, or for whatever reason you didn't like the name you were born with and you changed your name, that change of name process that you went through with Home Affairs and advertising it in the government gazette, in the paper, you have to have that proof of name, because somewhere along the line your name has legally changed, and so we need that proof when you pass away as well. It's different if you are still using Mary as your ID and your passport and all your documentation, and you're known as Maryam, and you are Muslim, but you're known as Maryam in name only, but legally you're still Mary. That's absolutely okay. We'll still just use Mary, your ID, but also known as Maryam. So very important that all of that original documentation is kept somewhere. Have hard copies and have it electronic. I mean, you don't want someone not to be able to access your laptop when you pass away, or know your passwords, and then all your documentation's electronically saved and not originally. If you're our client, certainly give it to us. We keep everything in safekeeping free of charge. Certainly check with your attorneys, check with your accountants if they can keep your originals. Otherwise, make sure it's in that specific bag or that drawer and the whole family knows where it is. Your original will, of course, very important. And destroy any other will. So as soon as you've updated a will, please tear up all the old wills. If you've got a title deed, make sure if it's no longer bonded, if it's bonded, the bank will have your original title deed. But if you've paid the bond and you've received your title deed, or if you paid cash for your property, you must have your title deed somewhere. It costs 6,000 Rand to get a duplicate title deed, and it's a long process with advertisement, and no one wants to go through that or pay that unnecessarily. So do look for your original title deed. If you've got any documentation like original share certificates, anything at all where you've got an original, please put that somewhere safe. Your rates, your rates account, yes, we can get that from council, but if you've got one, just keep it for your family. If you had your property, Yasmeen will talk to all the things you need for tax, but for capital gains purposes, be so handy for us as estate administrators if you've actually got all of that to help reduce your capital gains tax. So anything that you undertook, major innovations, all those sort of things with your various properties, please save that somewhere. I love getting that kind of information from people to reduce taxes as far as possible. E-filing, login details, please put that in your live file that we'll send. Attach that. Let someone keep that with your actual will, your e-filing login details. Just any original, anything to do with any asset that you've got. If you bought shares years ago, if you've got policies, it's not such a big deal. If you don't have your bank statements, we run those astute checks under your ID number, so we can kind of see where you hold bank accounts and policies by the time you pass away. But if you've got that schedule of all your policies and who the beneficiaries are and who's getting what, that's so handy. Just give that to your attorney to keep with your will. It's really fantastic if we've got all of that in one place. So your kids' birth certificates, all of that. And if you and one last thing, Uncle Zeinoul, if you've got one thing that gets uncomfortable is when people in a consultation say, I know that you've put down that's the Islamic shares and you've sent that off to the MJC, but actually that person my sister was conceived out of wedlock, and all those things about who's a legitimate child and illegitimate child. So I think just make sure that you notify your attorney when they're drafting the will that that's the scenario, so that we can deal with it properly. You don't want unpleasant things arising when someone's passed away. Shukran.
Or a second wife that's not disclosed to the first family.
Any last word from you, Yasmeen, and then we'll go on to Mufti.
I think it's good to have proper advice. So if you've got a trusted accountant or lawyer or Sharia scholar, get advice, because these are things that are riddled with pitfalls. It's best to consult. And depending on the value of your estate, I suppose it depends. It doesn't really matter the value of your estate. There's always pitfalls. It's best to consult, get advice where you need to. Hopefully not too, it doesn't need to be too expensive advice. And do the best you can. But I don't think you should do nothing. Definitely, as Mufti said, you definitely, at the bare minimum, need a will.
Jazakallah, Yasmeen. Okay, Mufti,
I just want to end off by saying that, we should always keep our akhirat and hereafter in front of us. It is of paramount importance. We live for the hereafter. That is why we live. And we are only custodians of the things Allah makes us custodians of in this lifetime. I often tell people, even if you own property, in dunya we all are on rent. That's the reality. We're just holding it for a little while, and we're going to pass it on to someone else. And therefore, we should put our wills in place. It's something that is extremely important. And we should not attach ourselves so much to worldly possessions that we want to dictate from the grave who must be, who must get what we worked hard for. We don't have those rights, and we never got anything on account of our hard work. That's the reality. We got it because Allah subhanahu wa ta'ala made us custodians of it, and we're going to have it for a certain period of time, and then we have to pass it on. And we need to make sure that we pass it on like how Allah wants us to pass it on, and therefore the importance of having our wills and affairs in order. May Allah subhanahu wa ta'ala guide us and grant us the correct understanding of all of these matters.
I mean, Jazakallah khair. And, if I can also just say a last word, that we constantly reminded also that Allah subhanahu wa ta'ala is al-warith. He is the ultimate inheritor of everything. So what we have is basically temporary. What we have is never ours. What we give away is always ours. And that's like an Islamic proverb as well, and a Quranic injunction, guidance as well. So
in the Islamic economy, Uncle Zeinoul, in the Islamic economy, we never measure our worth by how much we have gathered for ourselves. We always measure our worth by the impact we have had on the lives of others.
Ameen. Alhamdulillah. So, Jazakallah to everyone that has participated. I'd like to also, at this juncture, just give a token of appreciation to all the panelists here. Rumana, if you can give us the certificates for our panelists, if you're still there. Rumana, I think she's left us. Anyway, we will send this to all of you. In terms of, okay, Rumana is back. Looks like it. So can you put that on the screen, Rumana? Okay, she says 1 second. So it's just a token of gratitude to all of you for having been with us for just more than 1.5 hours. Actually, we have run over on time.
We have been encouraged so much to learn about the laws of inheritance and our Deen and Shariat and Rasulullah sallallahu alaihi wasallam, different narrations actually refer to it as فَإِنَّهَا نِصْفُ الْعِلْمِ. It is half of knowledge. So it's a very, very important aspect, and we really can't overemphasize the importance of the laws of succession in Islam. Jazakallah for that certificate.
It's a pleasure, Mufti Sahab. So for you, a certificate of appreciation for Mufti Shafique Jakhura in recognition of the outstanding support and contribution to the Awqaf SA World's Week project. Jazakallah khairan. And then also to the next person who's there, to Refqah, Fataar, Ho-Yee. Also Jazakallah khairan to you, and also to Sister Yasmeen Suliman. Thank you very much. Jazakallah. May Allah reward you all for your support, and may you always be available to give people this kind of advice. I think it's so invaluable. The issues about worlds is so significant. We've seen really families actually being destroyed, where people are not even talking to one another. So it's so important that we have this kind of conversation, and we shouldn't be having it on an annual basis. It should be on a constant basis. We should be reminding one another. Also, those worlds that we talk about, and you mentioned it also, that there's constant change that takes place in our lives, and we should be keeping them updated. So with those few words, and Mufti Sahib, if you can close off with a dua. And we also remember the people of Palestine, people of Lebanon, and all the people, wherever they are, that are suffering in these circumstances that we are in a global situation. Muslims are really under a lot of stress at the moment, and we hope, inshallah, that Allah grants us, victory against all odds and against all enemies.
بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على أشرف المرسلين سيدنا محمد وعلى آله وأصحابه أجمعين. اللهم أحسن عاقبتنا في الأمور كلها وأجرنا من خزي الدنيا وعذاب القبر وعذاب الآخرة. اللهم كن لإخواننا في فلسطين وفي الشرق الأوسط يا رب العالمين. اللهم كن لهم معينا ونصيرا ومؤيدا وظهيرا، واحفظ إخواننا من بين أيديهم ومن خلفهم وعن أيمانهم وعن شمائلهم ومن فوقهم، ونعوذ بك اللهم أن يغتالوا من تحتهم. اللهم وسدد رأيهم ورميهم يا أكرم الأكرمين. اللهم وأنقذ المسجد الأقصى المبارك واجعله شامخا عزيزا إلى يوم الدين. وصلى اللهم وسلم على نبينا محمد وعلى آله وأصحابه أجمعين. We ask Allah subhanahu wa ta'ala to accept our deliberations and to guide us and hold our hands and guide us and help us to navigate throughout our lives. وآخر دعوانا أن الحمد لله رب العالمين.
Barakallahu feek, Jazakallah khairan. Until we meet again, inshallah. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam.
Wa alaikum salam. Shukran, everybody. Shukran, Awqaf.